Now we will discuss the federal provision under Indian constitutions, right. So, if you see the term federal or federation, the term federation not mentioned or defined under Indian constitutions. So, the term federal or federation has not been mentioned in the Indian constitutions, nor it has been defined. So, how we can say that India is a federal nation if the term federation is not been mentioned? To understand the nature of Indian states that described India as a federal nations through the Article 1 of the Indian constitutions. So, Article 1 of the Indian constitutions described India as an union of states. Union of states. Now, we have seen when we have compared the union of states in terms of India and union of states in terms of America. So, we have seen the formations of union, right. Now, through the Article 1 which talks about India, that is Bharat is a union of states. It means two things. First, that the states are not allowed to secede from union, right. So, first the states are not allowed to secede from the union. They cannot part away from union and form another union, or they can join another union. This has not been allowed in the Indian constitutions when we talk about union of states. The second thing which implies through the union of states, which we have already seen, is that the union is not a product of, union is not a product of agreement between states. So, we have seen while differentiating between the American federal systems and Indian federal systems under the mode of formations, that the union is not a product in India as an agreement. So, how the union forms? So, to join a union of India, the states have to surrender their sovereignty. They have to accept the union without having a sovereignty with them. So, this is what the union of states means. So, this forms that India, though it is not mentioned in the constitution that India is a federal nation or been defined as a federations or been mentioned as a unitary in the form of government, but through the union of states we can say that states have been given certain power. So, now we will see those feature of Indian federations which present in the Indian constitutions, through which we can say that India is a federal in its nature. So, now let us discuss those provisions which indicate that India is a federal nations. So, the first features with respect to the Indian Federation is a written constitutions. As we know that India has a written constitutions and it also an world lengthiest constitutions which we all know, right. So, there are another types of constitutions, unwritten constitutions like Britain, but unlike Britain, India has a written constitution. So, this is one of the features which shows that India is a federal in its character. Next shows rigidity of constitutions. Now, when we talk about the rigidity of constitutions, so it means that the amendments to the constitutions in a federal systems is not through an flexible way. To make an amendments to changes in the constitutions, a rigid process has been given under Indian constitutions, which dealt under Article 368. So, whatever changes with respect to the federal character has to follow the certain process mechanism which is already been mentioned in the constitutions, and that mechanism makes it a rigid. It means that the concurrent or the consent of the states at some point of time is required, which is given under Article 368. So, the formations or to make changes into the constitutions is not a flexible, that the state cannot, center cannot make changes by its own, they require the consent of the state also. Clear? So, second, rigidity shows that Indian constitution is a federal constitution. Third feature is division of power. Now, according to Article 246, which deals with the list given in Indian constitutions, and under 7th schedule of the constitutions, which talk about 3 types of list: union list, state list and concurrent list. So, it has demarcated the areas of the union and states for its jurisdictions. So, the functions of the states and union has been demarcated through the list, right. So, because of this, and we have already seen the division of power where the two governments is been restricted in their respective sphere through the list, through the provided subject matter, that on what subject matter the union can formulate a law and on what subject matter the states can formulate a law. So, Article 246 talks about division of power. This also shows that Indian constitution is a federal constitutions. Now, if you see the next features of the federal constitutions which is present in Indian constitutions is an independent of judiciary. Now, judiciary in India, as we have seen, is an integrated judiciary and it's also an independent judiciary. Independent judiciary means the judiciary is free from the control of executive. Executive has no role in judiciary, right, and this also can be seen through the Article 50 of the constitutions, which talk about that separation of judiciary from executive. So, this is one of the features of federal system can be seen in Indian constitution, that Indian judicial system is free from the pressure, from the interference of the executive. Though it is appointed by the president, though the judges were appointed by the president, but on the advice of a collegium system in India. So, appointment though lies with the executive, but there is no full control of executive on its appointment. Getting my point? They can only appoint, the executive can only appoint those individuals or those person as a judge in a Supreme Court or High Court, which is to be forwarded by the collegium systems, which is a compositions of a judges. So, judges will decide that who is eligible to become a judge of a Supreme Court or High Court. So, only that person can be appointed by the executive, that is president. Clear? So, appointment is also independent and their removal is also very important. A removal process also makes them independent. As we know that they can be removed by the president. So, can we say that the judges are under the pleasure of president? No. Why? Because president can only remove judges if the motion is passed by the parliament. So, again on the ground of proved misbehavior and proved incapacity, the parliament will pass a motion. In that context, then only they can be removed. So, the independent nature of judiciary is kept under the Indian constitutions, and by keeping the judiciary independence, it ensures the supremacy of constitutions, which is again another feature of the Indian constitutions. So, Indian constitution is supreme, is above everything. So, every organ of the government, whether being its executive, whether being an legislature, whether being an judiciary, they all are deriving their power through the constitutions. So, constitution is a supreme in nations, and the role, the judicial role is to keep intact the supremacy of constitutions. Clear? So, this is another features. Next is dual government. As we know that the federal systems where the power between the two government or the relations between the two government is divided. Center having a defined power is restricted power, and state has a different or defined power. Clear? So, again the dual government, one government at the center known as a union government, Another government at the state known as an state government. Clear? Now, the supremacy of constitution we have seen, and the last features of the Indian under the Indian constitutions which indicate that India is a federal system, that is a bicameralism, means having a two houses, right. So, parliament having a two houses, Lok Sabha and Rajya Sabha, upper house and lower house. This also indicates the bicameral nature of federal system under Indian constitutions. Clear? So, this portions indicates what are the features present under the features of a federal system presents or federalism presents in Indian constitutions, and this part contained or impose, or we can say that have an very importance in asking a questions in the prelims. Also, prelims has been many a times in the prelims this has been asked a question that which of the following feature is an part of an Indian constitution which indicate that India is a federal systems. Now, if we see among these features, if I ask a questions that which among the following is an essential feature of the federal system in Indian constitutions, it means if that system is not there, it cannot, the federal systems cannot exist, or which the federal system is not possible without the existence of that certain particular feature of the federal systems. So, the essential to the federal system is an independent of judiciary. So, this is an essential feature, most important feature of federalism in Indian constitutions, because it is the one organ of the government who is keeping the supremacy of constitutions, intacting, validating the supremacy of constitutions, which is there to intact the division of power. If there is an intrusion of parliament or intrusion of union into the state, so there will be a judiciary to restrict that this is not your area, you cannot make laws on certain matter which belongs only to the states. So, only the independent judiciary can ensure that the federal system can exist. So, the most essential among them is independence of judiciary. Clear? So, these are the features which indicates that Indian system is a federal system, though the term federation or federalism or a term federal is not mentioned or neither defined in the Indian constitutions. Clear? Next, we will see the reason for opting for federal systems. So, why India choose for a federalism? Why not for the unitary systems? So, there may be a reason that why we have gone for the federal system, why the founding fathers of the constitutions have decided to go with the federal systems without mentioning the term federations. So, there are three basic reasons for this. The first is size of the country. So, India having a very huge size in its geographical terms. Second, diversity in terms of socio-economic or socio-cultural. We have a socio-cultural diversity, right? And third, there are numerous indigenous peoples residing in India. So, these are the three basic reasons that founding father of the constitutions has chosen for the federalisms, the being the size of the country. So, they believe that for the huge size of the country and for the being a diversifications in the socio-cultural matters, it is only the state who can decide that what law they want to come up or what law they can make for the betterment of that socio-cultural diversity. We have a very diverse in the language, we have a diversity in the religious, we have a diversity in terms of caste, we have a diversity in terms of race. So, if the power is to be given at the center, if we have opted, suppose that we have opted for the unitary form of government where all the power concentrated at union, so it is not feasible for the union to make laws or to get into concern with each and every individuals or the each diversified groups their concern would be met. This can only be happen if we follow the federal systems, where the particular state is empowered to make laws, rules and regulations to provide a better opportunities for this diversifications. So these are the reasons why we have chosen for an federalisms. Is it clear? Right. Now moving to the next topic under this center state relations, as we have seen that Indian system is a federal systems. So do we can say that India is a true federal as an American, or there is a different form of federal system in India? So we all know that Indian federal system were known by different name, that is India is a quasi federal, or Indian Federation with strong center, or Indian federal system tilted towards center. These are the nomenclature given to the Indian federal systems, that it is not truly federal as America, it is a quasi federal, means India having certain provisions of unitary also. Now when we talk about the quasi federal, it means that it is having some features of federal, plus it is also having some features of unitary form of government, where provides unitary form, where the center has been given more power. Because of this nature, India is also known as a federations with a strong center, means the center is very strong. Because of this nature, it's also said that though India follows a federal system, but it is tilted towards center, means providing the center more power. So what was the reason that they come up with this provisions, that we should not follow the federal systems, true federal systems, though we have a federal system, but not true as an America, rather we should follow the Canadian model. Instead of American model, that is having a strong center. So reason behind the opted for the federal system is strong center. So the first reason, again the same, that is diversifications. We have a very diverse society. So in the diverse society, where we have a diversifications in terms of religion, we have a diversifications in terms of language, we have a linguistic diversity, we have a caste, a diverse caste is there, a diverse creed, race is there. So to get every individuals a due representations, that every groups, every caste, every religion should have their interest be served, it is necessary that the power should be given to the state at the same time. This was the deliberations in the Constituent Assembly while forming the constitutions. But the major incidents happened during the period was partition of India. Partition of India in 1947. This has shocked the framers of the constitutions. Now they are in the dilemma whether we should go with the unitary to avoid any such incidents in future, disintegrations of states, or whether we should interact with the federal systems, whether states should be given sovereignty. So they come to the conclusions, first to give diverse society representations, and plus the reasons for opting for the strong center, that to avoid any future disintegrations, thus Indian constitutions or the framer of Indian constitutions has provided the more power to the center in normal times also, where the center have a control over the states in certain specific matter. Through this, the framers has ensured that in the future the incidents like partitions can be avoided, not providing the states a sovereignty in itself. If a sovereignty would be provided, they may again disintegrate from the state or the nations and join the Pakistan, or they may be declare themselves independent. So, for the integrity and for the unity of India, that the nation should be united and such incidents of disintegrations to be avoided, they have opted the Canadian model, that is of an Indian federations with the strong center. And the exact question has been asked in examinations, that what are the provisions or why India is known as a Indian federations with the strong center. So, now we will see those provisions under Indian constitutions which make India at a time of federations, but having a feature of strong center, where the center has been more power and have a control over the states also, right. So, now let us discuss those provisions under Indian constitutions which indicates that it is having a more tendencies or centralizing tendencies. Clear? Chaliye, let us discuss. So, the provisions which creates a strong central government, the first is single citizenship. So, single citizenships, as unlike the USA where there is a dual citizenship, the citizens of state is also been given, Indian constitution has a provisions of single citizenships. The persons is only citizen to Indian Union, not to their respective states, and through the single citizenships, the framers has ensured to curb the feeling of regionalism, and through the curving regionalism feeling, it has ensured that disintegrations from the Indian Union will be curbed. So, providing single citizenships. Now, single citizenship, it means that irrespective of their states, irrespective of in which state they are born or in which state they are been residing, all the citizen of India having a loyalty towards the center, towards the union. We as a citizen of India have no loyalty towards our state. We are a citizen of India. So, we show our loyalty, allegiance towards the center. Clear? First provision under Indian constitutions which indicates that Indian federal system having a centralized tendency. Second, Article 3 of the Indian constitutions. Article 3 of the Indian constitutions talks about formations of new states. It means that it is a parliament who is empowered through the constitutions by Article 3, that parliament can divide a single state into two or more states, or it can merge the boundary of a state, or it can rename the states, like for example, in 2000 Bihar was bifurcated into two, Bihar and Jharkhand, done by the parliament under Article 3. Madhya Pradesh was bifurcated into Madhya Pradesh and Chhattisgarh in 2000 by Article 3. Andhra Pradesh bifurcated in Andhra Pradesh and Telangana. Recently, the state of Jammu and Kashmir was bifurcated into two union territories, Ladakh and Jammu and Kashmir. So, this power of bifurcating, merging often states in two or more states is given to the parliament, and that's also this also without the consent of state. So, state consent is not necessary. If the state objected this move of the parliament, they have no power under the Constitution of India to restrict or to put breakage on that move of the parliament. So, through this article 3, it ensures that the parliament or the center or the union, whenever is of an impression that some state is going to behave in certain matter, if they have an apprehensions that the state is going to act or is in a position to disintegrate, they can break that state into two halves, or they can merge with the different states. This power given the control of the parliament in the state's territorial integrity. So, the constitutions through the article 3 does not guaranteed the territorial integrity of states in India. And because of this nature of the Indian constitutions, India is known as indestructible union composed with or of destructible states, which means that though the states are not allowed to secede from the union, they cannot part away from the union, but the union has a power to bifurcate the states into two or more states through article 3. This has provided them the power to the union, and through this the power is given to the center union to interfere into the state's territory, and through this it has a control over the states. So, this also shows how the center has been strong, though we are following a federal systems. Clear? Next provisions which makes the strong center under Indian constitution is integrated judicial system. Integrated judicial systems. As we have seen that India, though having an independent judiciary, but it is also having an integrated judicial systems, which means the courts have no provisions of division of power. Unlike between the two government, division of power is made. Indian judicial system and Indian courts were put under the hierarchy, top at the Supreme Court, then the High Court, then the subordinate court, and all are under control by the Superior Court. So, this also indicates that the Supreme Court has a control over the state's legislature. It also means being because of the integrated judicial system, the Supreme Court can deny or invalidate any state law. But in the true federal nations, where the USA, as we have seen, there is a two policies of two court systems. The federal court is not interfering in the state law. But in India, to make the state center strong, they have opted for the integrated judicial system. Clear? Next is emergency provisions. Emergency provisions. There are three types of emergency: national emergency, state emergency, and financial emergency. And all these three emergencies were imposed by the union. So, union can through president can impose an emergency, and state also, that is known as a president rule. Failure of state machineries or a state emergency, and by imposing the emergency in the state, whether being an national emergency or state emergency, the union parliament and the executive have a control over the state legislative affair and also have a control over the state executive affairs. So, this also indicates how the time in a normal time period the center can control the states, and through financial emergency the union also have a control over the financial matter of the states. During financial emergency the state cannot move any money bill or any financial bill without the sanction of the president. So, it means they have to take first the sanctions, permissions from the president to move any type of financial matters in the legislature during the financial emergency, which also indicates that they are under the edges of center. Clear? Next, all India services. Now, if we see that the states are administered or a country is administered through the administrations, all India services like IAS, IPS, there are three types of all India services: Indian Administrative Service, Indian Police Service and Indian Forest Service. And they are entrusted with the administrations of the country, right? But the recruitment of them, posting, appointment is all done by the union. State has no role in their appointment, state has no role in the recruitment, but they are working in the state. They are helping the state government in delivering their functions. So, through all India services, the center is also controlling the state, because the state cannot play a role in their removal, state have no say in their appointment, states do not have a say in their recruitment also, but they are deriving their salary from the state government, which indicates that through this systems, all India services system, the center have strong control over the states in the administrative part also. Clear? Next, if say unequal or unequal representations of state representation in the Council of States. So, we have just seen that the states in India are represented in Rajya Sabha on the basis of populations. So, the state with the highest populations will have an highest number of representative in the Rajya Sabha. The state with the least populations will have a least number of representative in the Rajya Sabha, and through this representative, if the states having a least representative, so the majority of the state or the state which is having a more number of representative, it is high chance that the voice of the least represented states cannot be heard by the government. And through this also, the center has a control over those states who have least representations. Clear? Next, if we see the second part of the provisions, those which makes center more strong, is appointment of governors. Now, governor is known as head of state, constitutional head of states, constitutional head of state. But the appointment of governor is made by the president, which belongs to the union executive, and they will be posted in a state. Removal of governor is also done by this appointment, and removal of governor also done by president, but the president is to head as a constitutional head, function as a constitutional head of the state, but the state have no say in their appointment, the state have no say in their removal. That all depends upon the union government. So, they can appoint any person to any state as a governor, and the state cannot deny, or the state cannot make their voice heard to the government that they do not like this person as a governor. That is why we are seeing many conflict between the state government and governor, because governor is not under the control, is not been appointed or elected by the states, rather they have been appointed by the union executive. Clear? Next, centralized election machineries. Now, as we know, in a democracy, it is important to conduct elections on a regular interval, right? So the parliamentary elections or state legislative elections, that all been conducted by the Election Commission of India, which is again a centralized election machineries appointed by the president, appointed by union, and removal by the union. States have no role, though the Election Commission of India is responsible to conduct election of the state legislature, whether being an assembly or council, but the states have no role in their appointment, in their removal. All is to be controlled by the union. Through the Election Commission also, the center is controlling, right? Next, integrated office of CAG, Comptroller Auditor General. So CAG is there to audit the financial account, budget of the state government or union government, if any misappropriation of fund is done or not. So auditing is necessary, but that is done by the CAG. Again, the CAG, which is an appointed or by union, but entrusted to audit the account of state. Again, the state does not have they do not have any separate auditor. They all are dependent on the CAG, and in that dependence they do not have any say in their appointment, whether they like the person or not, whether they like the behavior of the office or not. They have nothing to say in that. Only they have to follow the rules that is provided by the constitutions. Okay? Next, parliamentary authority over state subject. Do the parliament have an authority over the state subject? Yes. During emergency, as we have seen, during emergency, the state subjects come under the control of parliament. In normal time period also, when the Article 249, when Rajya Sabha pass a resolutions that the parliament is authorized to make laws with respect to the state subject, then parliament can intervene in the state subjects, though the constitution has provisions of division of power restricting the jurisdiction of parliament, that it cannot interfere in the state. But there are certain provisions which says, like emergency, I have said. In emergency, if there is a national emergency all over the India, during emergency, India acts automatically without making any amendments to the constitutions. It functions as a unitary government, that all the administrative, executive, legislative decisions of the states is taken by the center, by the union. This is the provisions under emergency. But this is not only a case when the emergency is in operations. During the normal period also, if an Rajya Sabha through Article 249 passes a resolutions, and through that resolutions it empowering the parliament to intervene into the state subject, right, or to implement international agreement. The parliament can enact any law which comes under the state subject, and that even without the consent of the state. Agreement, treaty, conventions of any bilateral relations between India and US, or a multilateral or we can forum like BRICS, Quad. So any decisions of the Quad, if India has been agreed to that, it will make a law to implement that, even if the subject matter falls under the state list. So while formulating a law with respect to the to implement the international law, it is not going to concern with the state agreement, or their consent is not important. Clear? Next, veto over state bill. So do the union has a veto, they can deny the any state bill. Yes, there are two articles under Indian constitutions. Article 200, which empowers the governor to reserve certain state bill for consideration of president, and Article 201 allows the president with respect to above bill to veto over the bill, though the bill is been formulated by the popular government of the state. The state government is chosen by the people of that particular states, but still the provisions in the constitution says that if the governor reserve that bill for the president, so president can deny the assent to the bill, and once the president denies the assent, it means it has vetoed the bill will not become an act. So this also can be said that India is showing, though it has given a power, independence to the state, but in true sense Indian states are not sovereign in themselves. They come under the control of the center. So the questions may be asked in a different language, that Indian states are not sovereign itself. So the answer will be same. The sovereignty of the states does not lies with them. It means that they are under the control of the center. How the constitutional provisions indicates that control of the center over the states. It means the states are not sovereign in the nature, right? Next, financial dependence on the states. So in the financial matter also, the states are dependent on the union for the grant, GST, taxes. Many a times the states are been asking for the grants or loans from the parliament, union. During the financial emergency, the president can deny the introductions of a financial bill or money bill into the state list or the state assembly. This shows that they are financially dependent on the union. And the last is residuary power, which means that if any subject matter does not fall under list second, that is state list, or list third, that is concurrent list, so it is constitutional rights of parliament to make law on that subject matter. That is residuary power. If we compare the residuary power with the American residuary power, in America, it's being a true federal, it has provided the residuary power to the states. But in India, having a centralized tendency, having a tilted towards center or strong center or a quasi-federal, the residuary power are given it to the parliament. Clear? So these are the provisions which indicates that Indian federal system, though it is a federal in nature, but it's not completely or truly federal, having a centralizing tendency, tilted towards say center or a strong center. Okay? Chaliye, now we'll discuss the next concept. Now we will come to that topic. What we have started our discussion is that center state relations. So center state relations could be studied under three heading, that is on the basis of legislative relations between the center and states, administrative or executive relations between the center and states, and a financial relations between center and states. And in terms we will discuss each of these separately, that what are the constitutional provisions which indicates the legislative relations between center and states, what are the provisions, whether they have been sovereign in the sphere or not, whether there have been independence in the particular sphere, respective sphere or not, how the administrative relations been defined in the or been managed under Indian constitutions, and what are the provisions related to financial emergency, financial relations, right. So, we will start with the legislative relations. So, legislative relations between the center and states is having on the two lines, territorial jurisdictions and subject jurisdictions. But before starting the discussion of a legislative relations between center and states, we should know one important fact is that neither the Indian Parliament nor any states are truly sovereign in legislative matter. We have seen that the states are not sovereign in their respective sphere because the center has more control. But the provisions of constitutions also says that the parliament is also not sovereign, though it is independent, but it is not sovereign. Now, what does it mean? That means not being a sovereign in its nature, it means that there are constitutional limitations on their legislative power, So, there are constitutional provisions which limits the power of the parliament in respect of legislature and also restrict the power of state in terms of legislature, which indicates that they are neither parliament nor states are sovereign in the nature. So, we will discuss also this, that what are those restrictions which impose restrictions on legislative power of the parliament and also the legislative power of state, right. So, legislative power has been distributed among the two line, territorial jurisdictions and subject jurisdictions. It means the territory has been divided, subject is also been divided, which shows the division of power, right. Now, if we talks about the territorial jurisdictions, so when we are talking about territorial jurisdictions, what does it means? Jurisdictions. So, if we see union and states, so union parliament is entrusted to make laws with respect to any part of India or whole of India. So, which body is entrusted to make laws for the whole of India? It is parliament. It can make, if the law is made by the parliament, so it is equally applicable from Jammu and Kashmir to Kanyakumari, from Gujarat to Arunachal Pradesh. So, this is an extensions in terms of territorial jurisdictions. So, in terms of territory, India has a wider, or parliament has a wider jurisdictions, but when we talks about the state territorials, so it is restricted only to the territory of state. So, state legislature, when it is making laws with respect to any subject matter, it can only make laws, only that laws is implemented and applicable only to the territory of that state, extent of that territory. Whereas on the other hand, the parliament has a power to make laws for whole of India or any part of the India, including the state also. This is the first jurisdiction under territorial. Second, extraterritorial jurisdictions. Extraterritorial jurisdiction. So extraterritorial jurisdiction lies with the parliament, not with the state legislature. So state legislature has no extraterritorial jurisdiction. It lies with parliament. It means that any laws made by the parliament will be equally applicable to the citizens residing in India or their property in India, plus any citizen residing outside India or their property in outside India. So they are all equal subject to the parliamentary law, like NRIs. So income tax is applicable to Indian citizens, similarly to the NRIs also. Any Indian companies like ONGC, LIC, if they are having any offshore branch, so they are equally following the law made by the parliament. So if we talk about the extraterritorial or territorial jurisdictions, that lies with the parliament, but this does not lies with the state legislature. State cannot make any law which is to be implement or apply outside its territory. So constitution has restricted the state legislature with respect to the territorial jurisdictions, that it can only make law for the territory of the concerned state, not beyond that state. But parliament has been empowered to make law extraterritorial also. So this is a territorial jurisdictions. Now when we talk about the second distribution, that is subject jurisdictions. So under the subject jurisdictions, which is governed through Article 246, which talk about the division of power, and this has been done through the 7th schedule. So 7th schedule talked about the 3 types of list: union list, like defense, like foreign affair, like citizenship, like railways, etc. all comes under the union list, which indicates that it is only the parliament who is empowered to make laws with respect to any of the subject matter which is enumerated under the union list. So states are not allowed to interfere to make laws with respect to those subject matter which are enumerated in union list, and this is the first list under 7th schedule. It talks about 7th schedule also. Under 7th schedule there is a state list, like public order, prison, local self-government, etc. all come under the state list, which means the state legislature are empowered to make laws with respect to those subject matter which is under the state list, that is second list of 7th schedule. This shows the division of power, and this also are legislative distributions on a subject matter, that on what subject which government is going to make laws. So parliament is going to make laws on those subject matter only which are enumerated in the union list, whereas the state legislature are going to make laws on those subject matters which are enumerated in state list. So that power has been divided. And the third list which comes under the 7th schedule is concurrent list, right, like IPC, CRPC, contempt of court, excluding contempt of court related to Supreme Court. These comes under the concurrent list. Now what does it mean? It means that whatever the subject matters is under the concurrent list, it is both empowered by the constitution, that is parliament and state legislature, to make laws on those subject matters. Is it clear? So this is jurisdiction, distribution of legislative power. Here we have seen that the states are been restricted through the territorial jurisdictions, only can make laws with respect to the territory of India, territory of the particular states, whereas parliament is empowered to make laws with respect to the whole territory of India or a part of territory of India. And with respect to the subject matter, the states are restricted to those matter which is enumerated in the state list or concurrent list, whereas the parliament is enumerated with the restricted with the union list or concurrent list. It's clear? So this is the distribution of legislative power. But as I have said that neither the parliament nor the state legislature are sovereign in itself. It means there are certain, it means they are under the certain constitutional limitations. They are not sovereign in themselves. They cannot make any laws. They can only make laws which are been entrusted to them with respect to the constitutions. So now we will see the limitations first to the territorial jurisdictions of the parliament. This is limitations to the territorial jurisdictions of parliament. As we have seen that parliament has an wider territorial jurisdiction. It can make laws to respect to any laws which can be extended to whole of India or any part of India. But there are certain limitations also, and that limitations governed through Article 240 Clause 2, 5th schedule and the 6th schedule. So these are the three limitations imposed by the constitutions which restrict the parliamentary power of making laws, and this shows that how the parliament is not a sovereign in its nature. And sovereign means we all know that without having any restrictions, without having any pressure, but the restriction imposed by the constitution itself. Article 240 Clause 2 talks about certain areas like Daman and Diu and Dadar Nagar Haveli, Andaman Nicobar Island, Lakshadweep Island, Puducherry. If the state legislative assembly is not in session, means dissolved, or president rule is there. So in such case, it is a president who through notifications make laws. President through notifications. And president has a power with respect to these areas, Dadar Nagar Haveli or Daman and Diu, Andaman Nicobar, Lakshadweep or Puducherry if there is no state assembly dissolve or president rule is there. So the president through notifications can give or indicate that any law made by parliament then may apply to this area or may not apply to this area. And this is how it shows that restriction imposed on the parliamentary power to make laws in territorial jurisdictions, though this all comes under the territory of India, right? And being the supreme legislative body of India is a parliament, so accordingly it has to be a parliament who is to be make laws respect to all territory. But constitution restricts its territorial jurisdictions by 240 Clause 2. It giving power to president, that through president it can make any laws that is to be equivalent to parliamentary law, or it can says that any law of made by the parliament may apply to this area or may not apply to this area, that is given to the president. This shows how the parliament is restricted in its territorial jurisdictions. Clear? Next, according to according to fifth schedule. Now, fifth schedule, as we all know, is related to the administrations of scheduled area and tribal areas, right? So it says it is an administration of scheduled area or tribal area. So it is a governor of the states who is empowered by the constitutions that through notifications it can modify or nullify any law made by parliament. So schedule 5 empowering the governor, that whether the act of the parliament may apply to those scheduled area which comes under the fifth schedule or not, that depends upon the governor. If governor says that the law will apply in a modification form, that has to be applied in the modification form. If the governor says that this law will not apply to this area, so that law will not be applicable to that area. This shows how the parliament is in territorial term has been restricted. This also indicates that parliament is not sovereign in its nature, right? Next, according to sixth schedule. Now, sixth schedule talks about administration of scheduled area and tribal area, but only in the 4 states, that is Assam, Tripura, Mizoram, and Meghalaya. Mizoram and Meghalaya. Fifth schedule is applicable to every scheduled area and tribal area excepting these 4, and these 4 were specifically dealt under schedule 6. So what does it say? It says that governor of Assam, and for rest of these 3 is president, who has been entrusted to decide that which of the laws of the parliament, act of the parliament, is applied in the same form or will apply in the modification form or will not be applied into the autonomous district of these states. So all these provisions of the constitution shows that parliament in terms of territorial jurisdictions has also been restricted by the provisions of constitutions, which indicates that it is not sovereign in its form or in its nature. Okay, chaliye. And in terms of jurisdictions, in terms of subject jurisdictions, we have already seen that how parliament has been restricted by the list, that it can only be makes laws with respect to certain or particular matter, subject matter, right? Now next we will see that what if there is a conflict between the law made by the parliament or a law made by the state legislature. So as we know that in a concurrent list where both parliament plus state legislature both are equally important to make laws or allowed to make laws with respect to those subject matter which falls under the concurrent list. But what if that parliament on a same subject matter has made a law and the state assembly also made law on the same subject matter? Then what will happen to that such law, right? Now suppose as I said that there is one law which is related to IPC or CRPC. Now suppose that on this matter the state has also made law and parliament has also made law, then there is a conflict. So in case of conflict, what happens? That given by the article 254. So 254 says that in case of conflict between the laws made by parliament and state legislature, the parliament law shall prevail. Shall prevail. But there is one exception to this. So whenever the parliament or state legislature both made a law on the same subject matter enumerated in the concurrent list, so there will be a conflict that which law should be applied, administration should implement which law. So in that case parliament law shall be prevail. But if, now there is a catch, now it says that but in this case, if, as we know that article 200 of the constitutions allow the governor to reserve certain bill, certain state legislative bill for the president, and president using power under article 201 has a power to assent that bill. This we know, right? So but if, so this says that in case of a conflict between the state and parliamentary law, so the parliamentary law will prevail, there is no doubt. But if the case is that, if the condition is that any state legislative bill is been reserved by governor for president and president has assented that bill, right? If the president has given the assent to the bill, so in that case this bill will prevail over the parliamentary law. Though in the normal circumstances, in the normal situations, the parliamentary law will prevail, no doubt. But if the bill is been reserved by the governor for the consideration of president and the president give his assent, then undoubtedly the bill which is assented by the president will be prevail over the parliamentary law. Is it clear? Okay. Now next, in terms of residuary power, so residuary power comes in the concept when if any subject matter is not mentioned under list 2nd or list 3rd of the constitutions, then it is parliament who can make laws on the matter. Clear? Okay, right. So here we have seen how the parliament legislative distributions of between the center and states. Now next we will see then at what circumstances can parliament intervene in the state subject matter. Is there any circumstances or there are no such provisions. So as I have discussed earlier that in terms of sovereignty, in terms of legislature, neither the parliament is sovereign, and we have discussed that what are the restrictions imposed on the parliament. In the terms of territorial jurisdictions we have seen. So now we will discuss that how the constitution has ensured that the state legislature also not being sovereign in its legislative affairs. So now we'll discuss those circumstances which allows the parliament to make laws in the state subject, or to make laws on those subject matter which enumerate in the state list second of the 7th schedule in a normal circumstances. Here we are not talking when there is an emergency. Here we are not talking about when there is an president rule. Rather we are talking only other than, or what we can say that including the emergency, there are the other such provisions also during which the parliament can make laws, not only in the emergency, but also there are certain provisions, certain circumstances where the parliament can make laws with respect to the state subject. Clear? The first, when it can make laws, which allows to make laws, is that in the national interest, and this is given under Article 249. So Article 249 says what? So it says that if the Rajya Sabha pass a resolutions with special majority. So if Rajya Sabha passes a resolutions with a special majority, so this resolutions will empower the parliament to make laws with respect to subject matter under list second of 7th schedule. So when a parliament can make laws in the national interest. So whenever the Rajya Sabha is of an opinion that it is required for the national interest, so they will pass a resolutions with the special majority. And once they pass the resolutions, it empowers the parliament that now you are authorized, now you have been constitutionally authorized to make laws on subject matter not enumerated in union list, but enumerated into the state list. So this is the first provisions when, or circumstances when distribution of power between union parliament are extended over the state subject, or when the parliament is empowered to make laws with respect to the state subject. Clear? First incident. Second circumstance is under the proclamation of emergency. So Article 250 says that whenever there is an emergency, so during emergency, parliament empowered to make laws with respect to state list. Okay. This we have already been discussed. Next circumstances, by agreement between the states, Article 252. So Article 252 says that whenever the two or more than two states pass a resolution, and through this resolution they ask the parliament to make laws on a common laws, to make a common laws on any subject matter under state list, then parliament is empowered to make laws on those subject matter. So through agreement 252, by two or more states, they can come together and they can pass a resolution. That through resolutions we have been requesting the parliament to make a common law for 2 or 3 or 4 states, and all that states will follow the same law. This also empowering the parliament to make laws, to intervene, to interfere in the state list. So this also shows how the parliament has a control over the state subject matter, right? Another, to implement the treaties, 253. So to India conclude any treaties with any international country or multilateral forum or a bilateral relations. So, whatever the treaty, conventions or agreement concluded by the India, whether with the bilateral, multilateral forum or any way. So, to implement that treaty, Parliament can pass law even on those subject matter which are under the list 2nd of the Constitution, and that is also without the consent of concerned state. So, this also empowering the Parliament to make laws. Clear? Right? And the last one, when there is an state emergency, is under proclamations 356. So, during a state emergency, the state government is suspended and there is no assembly. So, during this period, Parliament acts as a state legislature, or in the another term what we can say, that the power of state legislature transfer to the Parliament, and by this Parliament is empowered to make laws in the state subject. Clear? So, these are the provisions which shows that Parliament has a control over the state subject.